And welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a packed agenda of issues to discuss tonight. I want to welcome each and every one of you who are joining us on television in Berbice, West Coast Berbice, region number 5. Good evening and welcome to another program of Issues in the News. To those of us who are joining us on Facebook Live, who are joining us, on television, in Region 6, the east bank of the Berbice River, New Amsterdam, and on the Quarantine Coast, welcome to another program of Issues in the News. To those of you who are joining us on Freedom Radio from Robb Street, Georgetown, good evening and welcome to another program of Issues in the News. And last but not least, to all of our friends and followers who are joining us on Facebook Live across Guyana, the Caribbean, North America, Europe, Asia, and even further afield, welcome to another program of Issues in the News. And I want to invite you to share this program. Press that share button on your phone, press that share button on your tablet, press that share button on your computer so that as many persons as possible can join our discussions this evening. I see we have hundreds of you online already. Janvi Pandey, Chabi Raj, Sugrim, Julie Raha, Rajin Datadin, Frank Badrinarayan, Data Nandlall, Savi Dumont, and Remington Clark, and so many of you. Thank you, and continue to share this live, continue to press that share button on your phone so that we can have the widest possible engagement. And also, please ensure that you interact with us here on the screen. Send me your comments, send me questions so that I can attempt to answer them and make this program as engaging as possible. I want to begin tonight by informing that one set of the election fraud cases came up today in the magistrates court in Georgetown, and once again they were adjourned without a start. The special prosecutor, I saw him on the news explaining that there was a reluctance again to start the trials. The prosecutor, as he had indicated before, is ready to begin the trial. But there was a failure once again for the trial to be commenced. There was a failure in that the trial did not start as expected. Arguments continue to be advanced about separation of charges, about procedural issues, and these charges, and also whether one magistrate should try the case or the cases, or whether the cases should be tried by different magistrates, etc. The public is not really interested in those issues. The justice of the case is not, or the cases, the justice of the cases are not being advanced in that way. I am not at all advocating for an unfair trial. I would like a fair trial to take place, but fundamental to a fair trial is one that is conducted in a timely fashion. These charges are already 3 years languishing in the courts. I heard on the news the special prosecutor indicating, and I believe rightfully so, that a formal request will be made to the appropriate judicial officer requesting that a special magistrate be assigned to hear and determine these cases, or at least some other appropriate arrangement is put into place to ensure that these trials commence soon. It is not in the state's interest, it is not in the defense interest, neither is it in the public interest that these matters of national importance are delayed further. It is in the interest of justice, it is in the interest of the defense, it is in the interest of the rule of law, it is in the interest of the state that these cases are tried and disposed of as quickly as possible. Enough time has already elapsed. It is hoped that when the formal request is made to the appropriate judicial officer, a decision will be made that would be in the best interest of justice. A decision would be made that would ensure and assure an early commencement of the trial of these matters. And that is what I wish to say at this point in time. I will await for that formal request to be made, and we will anxiously await an urgent or early reply to that request. Hopefully, that reply would be one that assures the public that mechanisms are going to be put in place or will be put in place to ensure that the trials of these charges commence as early as is reasonably possible. Significantly and of immense interest is the fact that outside of the court, while these charges were being heard by the learned magistrate, was a protest being carried out by no other than APNU AFC. So APNU AFC were protesting, and they were shouting that they want justice, and these are trials involving Keith Lowenfield, Roxanne Myers, Mingo, and all those who were charged in the fraud or attempted fraud concerning the 2020 elections. One would have expected that the APNU AFC would have wanted to distance themselves from those charges and those who were charged. Lo and behold, they seem to have pulled off their masks, and they are now openly demonstrating that they were and still are in cahoots with those who attempted to perpetrate the massive fraud at those elections. So if you were in doubt about the APNU AFC's connection to the individuals who are implicated and who have been charged with the electoral attempt or the attempts at electoral fraud, today those doubts ought to have dissipated, because APNU AFC officially staged a protest in favor of the defendants in those fraud charges, or the defendants who are before the court in relation to those fraud charges. And they were bold enough to post it on their Facebook page. And I've asked my operator to show, and I believe it's on your screen, so that you can see for yourselves that APNU AFC, that political party, or that political coalition, are openly embracing those who are charged with perpetrating or attempting to perpetrate fraud at the 2020 elections. So the gloves are off, the masks are off, and they are now openly embracing the perpetrators of those dastard acts. So in the future, there can be no denial anymore. They have openly accepted that today, and I believe that that's a significant development for the public record, and I ask that it be noted. Today also, there has been another significant development in our courts. Chief Justice, acting the Honorable Madam Roxanne George, Senior Counsel, ruled in a matter filed by Seneca Henry, Charlena Nagir, and Andriska Torrington against the Environmental Protection Agency, in which these applicants were attempting to secure from the court a number of orders against the Environmental Protection Agency in relation to the EPA permit regarding Liza 1. They argued, or they asked the court to declare that the permit was unlawful, that the environmental law was not complied with, that the procedures were not complied with, that the flaring, the measure against flaring was unlawful, and a whole host of orders, all seeking, in essence, to stop the operation of the EEPGL on the basis that it was environmentally harmful and unlawful. This is one of a series of cases that have been filed by the same set of persons. In this case, as I said, it was Seneca Henry, Charlena Nagir, and Driska Torrington. There are others involving Vanda Radzik, Vanuta Radzik, Troy Thomas. None of them, except the unlimited guarantee case. Almost all of them have been struck out. In this case today, the Chief Justice ruled that the evidence presented was not relevant to the case, that the case did not have any merit, that a case was not made out, that the case was not only hopeless, but it was hopelessly presented. Her Honor dismissed the case, but awarded $150,000 costs. These litigants go on the internet, they pull down a whole set of information about the environment, pages and pages of document, half of which are irrelevant and 99% of which are inadmissible as evidence because the maker of those documents are not before the court. The principals are not even relevant, and they file these cases. Now, billions of dollars are being spent annually to resource the judiciary. Millions of dollars are expended in hearing and determining these cases. The state, through resources to the judiciary, expend millions and millions of dollars to hear and determine one of these cases. Then the state is invariably sued through one of its arms or agencies, and the state have to find resources to defend these cases. Lawyers have to be hired, time have to be consumed, research have to be done. Dozens of persons sometimes are engaged in one of these cases. And then in the end, the cases make no sense and they are dismissed as frivolous, vexatious, and without merit. But the courts do not express their displeasure by ordering appropriate orders for costs, as I believe they should do when the circumstances warrant it. Now, I am not against public-spirited citizens filing just cases. That's an important part of democracy. That's an important part of the rule of law. That's an important duty that citizens have to discharge. But the cases must be just. The cases can't be fishing expeditions. The cases can't be frivolous and abusive to the process of the court. The cases can't be so that persons are featured prominently in the press for bringing the cases. I recall when this particular case was filed, the Kaichor News carried a front page banner boldly asserting 3 brave women challenge the EPA and the legal permit. Nearly a year after, the case is dismissed as completely without merit, wholly abusive to the court's process. And the court, however, awards only $150,000 in costs. And this case is not in isolation. You have been following the number of frivolous, vexatious, and nonsensical cases that have been filed against the state. In particular, by politicians on the opposition side and these persons who are pretending or professing to be champions of transparency and the environment. And they engage the courts for months, sometimes years, and at the end of the day, the entire process turns out to be a complete and utter waste of the court's time, the court's resources, and the resources of all the parties involved. Now, we have an overworked judicial system that is nationally recognized. We have people with genuine cases involving their properties, involving their freedoms, involving families, cases that put people's lives on hold. And those cases remain languishing in the system. And these cases, these frivolous, vexatious, attention-seeking cases are heard and determined, and they turn out to be a complete waste of time. And a court, my problem is, the court must award appropriate orders in relation to costs. That's the point I want to make. When a particular judge ruled against the Environmental Protection Agency in relation to that unlimited guarantee, the costs awarded against the state in that matter was $1.5 million. Here, it's 150,000. That can't be fair. We have another set of cases of the same ilk pending before the court. One includes the challenge to the extension of Mr. Clifton Hickens' tenure as acting commissioner of police. I believe that that case is in the same mold. And you will see, let us await. But all I am asking, all I am commenting on, is that when these cases are dismissed, the courts must express their displeasure. They must send a message that it will not allow its processes to be used in this frivolous manner. It costs a lot of money to hear and determine one of these cases. I must mention that the Financial Action Task Force completed its mutual assessment of Guyana some time ago, and I believe that we did very well. We are awaiting a preliminary draft report of that mutual assessment, and we will be allowed to counter, to add, to subtract, to offer a different view, and then a final report will emerge. But I have participated along with many important state agencies, government agencies, and private sector agencies, and I believe that as a country, Guyana acquitted itself with distinction, and I believe that our financial structures and our legal structures that were under review withstood the robust scrutiny to which it was subject. As part of our continuous preparation to be a nation ready to combat financial crimes, organized crimes, and AML-CFT type offenses, the government of Guyana, through the Ministry of Legal Affairs, is collaborating or would be collaborating with the Regional Security System, RSS Asset Recovery Unit, in hosting yet another workshop in Guyana. That workshop is expected to be held later this month. I am looking for the date. The workshop will be during the month of October, on the 9th and 10th of October, and it will extend to the 13th, from the 9th to the 13th of October. The agencies that will participate will be judicial officers, magistrates, and they will participate in a separate engagement, and then the rest of important law enforcement agencies and state agencies will also participate. These will include the Attorney General Chambers, the Special Organized Crime Unit, the Office of Director of Public Prosecutions, the Guyana Revenue Authority, Customs Anti-Narcotics Unit, Criminal Investigating Department, Financial Intelligence Unit, the Guyana Gold Board, the Guyana Geology and Mines Commission, and the Bank of Guyana. The topics that will be covered include search and seizure of cash, production orders, how you get orders for persons to produce relevant documents that they have that are connected to these types of offenses, customers information orders, if you want orders for persons who have customers. How do you make applications for forfeiture of assets that are determined or believed to be connected or are the proceeds of crime? Then you have cryptocurrency and how you detect cryptocurrency issues, and fundamentals of money laundering, fundamental legal terms and concepts, the type of evidence that is required when one makes an application for these orders, like civil forfeiture orders, and a whole host of other issues relating to organized crimes, civil forfeiture, production orders, etc. So we continue to prepare the capability of the state to combat organized crimes and money laundering type offenses. So we have to continue, it's a continuous exercise, and we are having another workshop in Georgetown where our important personnel of state and government will undergo rigorous training as we continue our preparation. I have here to speak about the Opposition Washington Conference. But what is there to speak about? This was a conference that was built up and hyped as a massive event, an event that will expose racism, that will show how the government is discriminating, will show the establishment of an apartheid state in Guyana. It will show how one race is pitted against the other, and all manner of sensational, racist types of agendas were advanced. All manner of accusations were made, and the thing was hyped up for months. Months by those in New York. They went to Washington, and what happened? We were told that senators will appear. The leaders of the Democratic Party will be there. Long-standing, high, powerful members of the U.S. government And the US Senate will attend and will participate. Nothing of this sort happened. In fact, when I looked at some of the images of the conference, it was a total disaster. I did not count more than 20 people there. 10 or more were from Guyana. It was a complete and utter embarrassment, a complete and utter failure. Even their own event, they cannot organize and mobilize. They had only invitations, and they claimed they had FBI security. Invitations for 10 people turned up. When you took away the Guyana contingent, I don't think you had 10 people in the room, based upon what I observed from the video and other images. It was a complete and utter disaster. And the crazy one who organized it cuss out and abuse out all those who did not attend. Claimed Jeffries would attend, and I don't know who will attend. Nobody turned up. And whoever decided to give them an audience asked them the simple question. After their nonsensical diatribe, the question was asked, where is the data? Where is the empirical evidence to support what you are saying? And that was the end of the show. They have nothing. They don't have anything. They cannot have anything because they fabricate and they concoct. I have given them 1,000,000 opportunities to come forward and bring the evidence of the racial discrimination. I have sat on this program for months, and I've asked them to bring the person whom they claim did not get the COVID grant because of discrimination. Put them on the Facebook. Those who are discriminated against in relation to house lots, put them on the Facebook. Those who do not get the We Care cash grant, put them on the Facebook and let them speak. No. They can't do that. They speak about it. They stand in the parliament and they stand in the street corners and they go on their Facebook page and they speak about it. But they can't produce the people who are the victims. And they're not the victims because all of them would admit they collect because we have their names. They're known, so you know them. So they can't say because every time you receive money, you have to sign. So them in the parliament, they all receive. But they always have a phantom story of discrimination, that this one did not get and that one did not. But they can't produce the people. And that is why when they went to Washington and they were requested to produce the evidence, any form of evidence, they say that they don't have. They came empty-handed. They went to complain. Imagine they went to complain about rigging of elections. That the PPP rigged elections, that they won. And the people themselves, give us the evidence of your victory. Give us the evidence that you won the elections. But you know, once they ask them for the statements of poll, that's the end of the matter. Once they're asked about that statement of poll that Aubrey Norton says he has, that's the end of the matter. They can't produce. And that is the same type of narrative that they inculcate and they regurgitate and they spin. And that's why I call them the Kool-Aid gang. That is why I call them the Kool-Aid gang. They drink the Kool-Aid and they get invigorated and intoxicated with it. And you have to have a level of gullibility before you can drink the Kool-Aid. You can be persuaded to drink the Kool-Aid. You cannot be sound intellectually and drink the Kool-Aid. And that's why I call them the Kool-Aid gang. They have sat among themselves and they have persuaded themselves that there is an alternate reality, and they are now living it. It's a psychological disorder that they are suffering from. And when they go to the real world, they get a jolt because they can't produce anything to support what they're saying. One of them who loves to speak discrimination, every time she stands up in the parliament is a speech about discrimination. Got a lot of fancy antics, but never understands anything. Never is able to speak coherently on the matter at hand, whatever the matter is. So substitute substance and content for racial vitriol. And when she went there, she said, oh, it's because we don't have resources to accumulate the data. And then she attempts to explain, and she doesn't know the difference between 35,000 US, 35 million Guyana dollars, and 50 million Guyana dollars. And this is a person who portrays herself as a highly educated, highly sophisticated, highly intellectual individual, and randomly speaks about the opposition leader's office. A constitutional one, she says. A constitutional one to add greater sophistication. Only receives, and then that is it. From the time the statistics got to come, they're lost. 35,000 US, or 35 million Guyana dollars, or 50 million Guyana dollars. These are wide and varying and wide-ranging differences you're speaking about. These people don't have a sense of what is real. They don't have a value for money. They don't have... and they want people to take them seriously. They want the American government to take them seriously. And when they are ignored, and rightfully so, they cuss out the American government. They say the PPP buy out Biden administration. We are that powerful. We are able to buy out Biden's administration. That is the level of intellect and dialogue that they had at this major conference. This all-important conference that it took months to organize. And it was an absolute and abject failure. Anyhow, I thought that I would express my views on that because a lot of people ask me to express my views. There is a matter that I've been asked to speak on, and it concerns a protest, very small number of persons who continue to protest in front of the Attorney General Chambers and Ministry of Legal Affairs. These are persons, and I want to speak on that, so the press may have covered it. I hope that they carry my explanation. These are persons who are retired employees of Guyana Telecoms, Guyana Telecommunication Corporation. That's the precursor to GT&T. Older folks will recall that the company, when it was owned by the government of Guyana, it was called the Guyana Telecommunication Corporation. Those employees, when the GT&T bought out the company, those employees, they were provided for in the agreement. Some of them were paid off and were allowed to go, and some of them were kept by the new company. This set here, are claiming that government owes them pension. Now, this agreement was signed between the government of Guyana and the company that bought GTC. Since 1988, I was in Queen's College. Since 1988, this sale took place. And they obviously would have become employees of GT&T. And apparently they worked there until their retirement. How can they come to the government for pension? That's one. They took 25 years, I believe, before they then file a case. And the case is in the court system. I don't know. I believe that the case can't be won. But that's my view. I don't believe that they have a case. But the case is engaging the court system. I can't advise the government to dole out taxpayers' dollars to pay when there is no legal basis to pay. How can you work with a private company? It is impossible for any of the existing employees who would have been entitled to pension from GTC to be alive today. It would be impossible. They would have to be over 100 and something years. Because that agreement was in 1988 when all these workers came over. So the fact that they are alive means that they were long-standing employees of GT&T. They would have worked most of their life with GT&T. And whatever pension issues they have will have to be resolved by GT&T. And these are very, very old persons. Even if they do have a case, assuming that they do have a case, it is statute barred. You have 3 years to file a case of this type. 3 years you have. You coming 25, 30 years later to file a case, to claim. How do I justify as Attorney General advising the government to pay? What principle of law? In fact, my duty is to advise the government not to pay. Is that my money? I have to advise the government in accordance with law. We run a lawful government. So I thought that I would express some view on that matter because the protests continue in front of the AG office. And they know that the matter is in court. They met with the president. They met with me. I went through the matter. And I have to await the determination of the court. The placards are reading that I am cruel and the government is cruel. I empathize with them. They are senior citizens. But I can only advise the government to pay what is due, what is lawfully due by the government to whoever it is due to. Monday last, we turned the sod of yet another, the construction rather, of yet another magistrate's court at Anna Regina. And again, that shows and demonstrates the government's commitment to the judiciary, to the rule of law, to access to justice, and to the independence of the judiciary. You would have noted the number of new courthouses that are being constructed right across the length and breadth of our country. When we say that we are transforming Guyana, when the international press reports that Guyana is enjoying transformation, when the IMF in its report hails the progress being made by Guyana, it is not propaganda. It is transformation, not in one sector or in one area of endeavor. It is across national life. And the judiciary is not at all accepted. The legal sector, the judiciary, the Supreme Court, and all its institutions are part and parcel of the transformational process. We will have a brand new building to accommodate the Office of the Director of Public Prosecutions next year. That will be budgeted for next year. So the capability of the state is being enhanced. We recently imported 4 experts in the area of forensic sciences to work in the Guyana Forensic Laboratory. 4 experts in the area of ballistics, fingerprinting, forensic sciences, crime scene investigations, handwriting, document analysis, drugs and narcotics analysis, handwriting, analyzing all manner of forged documents, DNA testing and sampling. They have a wide variety of skill sets in the general area of forensic sciences. Highly qualified, highly experienced, and they will now work in the Guyana Forensic Laboratory to augment and enhance the state's capability to do forensic and scientific investigation into criminal conduct and criminal activities. We have to invest if we want to dent crime in this country. We have to invest in forensic sciences and in a scientific approach to crime solving. And that is the capability that we are building. I have asked the University of Guyana to engage these experts and for them to start to teach at the university so that we begin to build capability across the country, in particular in the investigative arm of the state and in the law enforcement agencies. The university has responded positively and will soon engage these experts, and hopefully we will see a new program of forensic sciences being taught as a certified and certifiable program at the University of Guyana. They will also be inducted as part of the training program of the Guyana Police Force to build capabilities in that important law enforcement agency of state. That is the type of transformation that we are doing in the legal sector, as is being done in every sector across the state apparatus. So when we speak about transformation, we are not doing it rhetorically. We are not doing it glibly, but we are doing it and we are demonstrating and illustrating how we are doing it. So I'm trying to look at your comments here to try to engage you, but the comments are very slow in, in coming up on the screen. Issues in the news, note, as the government of Guyana has done, His Excellency has spoken in this matter, note the acts of Venezuela, which have properly been construed as an attack on our sovereignty. We are rejecting those acts. We continue to rely on the 1966 Geneva Agreement. We continue to rely on the 1899 Arbitral Award. The Geneva 1966 Agreement says very clearly that if there is any dispute arising out of that award, then the parties must engage the Secretary General of the United Nations. Guyana engaged the Secretary General of the United Nations. Nothing came out of it. We went back and we reported, and it is the United Nations Secretary General that said that we must go to the ICJ, the International Court of Justice, and that is where we have gone. All of that is in the Geneva Agreement. And the matter is to be resolved at that institution. Venezuela is there as a party, and we must not do anything to undermine that judicial course which we have embarked upon. It is the Geneva, I heard an assertion by Venezuela that they are relying on the Geneva Agreement. Well, if they are relying on the Geneva Agreement, it's the Geneva Agreement that says that the UN processes must be engaged, and the UN processes must recommend how the matter is to be resolved. It is the UN Secretary General that recommended that the matter be resolved at the International Court of Justice, and we have accepted that. And we are there. And that process must be allowed to continue. That's what I will say on that matter for the time being. The government of Guyana, a few weeks ago while I was off the program for a bit, and made a significant decision that the government agencies, state agencies, and public authorities will institute civil claims seeking compensation against those who damage public and state properties. For too long, the state and government agencies have turned a blind eye to wanton destruction of public properties, state properties, and government properties. It takes billions of taxpayers' dollars annually to repair, renovate, and rehabilitate these destroyed properties. These destroyed properties are damaged recklessly, negligently, maliciously, and sometimes intentionally. Whatever may be the case, in addition to criminal charges, the state, as a matter of policy, will sue those implicated for compensation for the work done to rehabilitate. And we will also sue for damages for recklessness, negligence, carelessness, as the case may be. We have already sent a letter to a driver who is alleged to have drove into that roundabout at Eccles and damaging it, costing the government $2 million to rehabilitate a brand new, beautiful edifice or structure. The person to whom the letter was addressed has not yet responded, as far as I'm aware. He has been given 14 days to do so, and if he fails to do so, the action will be filed in the courts. This is not confined to traffic accidents, but all forms of damage to public properties, government properties, or the properties of public authorities. We have a duty to ensure that we do not deface and destroy public properties that require public monies, valuable public monies, to rehabilitate, restore, repair, and renovate. We have to ensure that we take a strong position. And I've seen many persons calling for the same in relation to private property, in particular, private property destroyed as a result of motor vehicular accidents. Well, the private individuals will have to take private actions. But there is going to come a time where the law in relation to insurance may have to be changed to allow for higher coverage for motor vehicles, so that those injured or properties destroyed can benefit from higher insurance coverage. Right now, because of the law, it's at a minimal level where the compensation that the insurance companies pay out bear no resemblance whatsoever to the loss that people sustain and suffer from these accidents. It's called third-party insurance, and the coverage is very minimal. And as a result, innocent people have to spend a lot of money either looking after themselves or repairing their vehicles and properties without any monies coming from the insurance companies of the guilty party. The law has been kept that way because if the law is changed, then insurance premiums will have to be increased drastically. As a considerate government, we have deliberately kept the insurance at a particular level because of the impact it will have on persons being able to afford insurance. And that is why we have kept it. Because once that law is changed and the insurance coverage increases, then minibus fares will increase, taxi fares will increase, and it will have a ricochet effect on the cost of living. But a lot of people now are complaining against it. And government may have to take a second look at the situation. Because We have to find ways and means of curbing the negligent driving taking place on our roadways and the negligence generally exhibited by road users in this country. We cannot continue with the carnage and the wanton destruction, the open carelessness which take place on the roadways of our country, resulting in injuries and deaths excessively over and above what we can afford as a country. We are still a very small population, and we must have, statistically, per capita, the highest incidence of road accidents. Worse yet, the highest incidence of road fatalities, at least in this hemisphere. And we simply can't continue to kill ourselves on the road. A responsible government can't sit idly by and watch a situation deteriorate in the way that we are descending in that regard. A responsible government has to take steps that may penalize certain sections of the population. But if that is what is required, what do you want the government to do? You may be driving very carefully on the road. You may be as sober as a judge. But there is a man whose vehicle is coming at you like a lethal weapon because of his carelessness, negligence, recklessness, or perhaps his intoxicated state. And for no reason at all, you can become paralyzed. You can lose a limb. You can suffer serious injuries. Worse yet, you can die. That is what we are dealing with here. So, we may have to relook. As I said, we have passed laws, we are reviewing policies, and we are implementing measures as we continue to fight against the reckless use of our roadways. It's a work in progress, and many other considerations will have to be taken on board as we try as a government, and that's what we have to continue to do, to bring order, to bring civility, to bring decency to the manner in which our roads are being used. Have you ever heard anywhere else in the world the vehicle horn used in the way that it is used in Guyana? Have you ever heard anywhere in the civilized world the level of decibels coming out of music systems in vehicles as you hear in Guyana? I don't hear them. Something is wrong, and we have to seriously address it. And drastic situations require drastic measures. I have gone beyond the program time this evening, and I want to thank you very much for staying with me for over an hour. I want to take this opportunity to thank you for being patient with me. I've been absent for a few weeks, but national duties, personal commitments sometimes become overwhelming, and I am unable to extricate myself from them, and that is what would normally cause me to miss a program unless I have some technical difficulty that prevents the airing of the program. So thank you very much. I will see you next week, hopefully, and we will continue this important discourse. Please enjoy the rest of the week. Take care, and I will see you next week. Thank you.